The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention.
Good morning and welcome to the Kansas Supreme Court. I would like to ask Mr. Doug Shima, the clerk of the appellate court, to please call the 9 o'clock docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Wednesday, February 3rd, 2021 consists of one case. Appeal number 121789, State of Kansas versus Sidney W. Clark, Reno County, briefs both sides. The appellee petitioner, Sidney Clark, has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Sidney Clark, and we are present and ready for argument.
May it please the court, Thomas R. Stanton, Reno County District Attorney, appearing on behalf of the appellant, in this case, State of Kansas. I am present and ready for argument.
Thank you, counsel. Mr. Dunn, you may proceed with your argument.
Good morning. This is a sentencing case that began when Mr. Clark was sentenced on June 9th of 2005. Back then, the district court found his criminal history to be B, based in part on the scoring of his 2000 conviction for placing bodily fluids on a government employee. That was an Oklahoma crime, and it was classified as a person felony, and the result was a 460-month prison term. In 2017, Mr. Clark filed a motion to correct a legal sentence, arguing his Oklahoma conviction should have actually been scored as a non-person felony, and the district court denied that motion. Mr. Clark appealed in what would be case 119076, and in an unpublished opinion filed April 19th of 2019, which will become quite an important date, the Court of Appeals reversed and held that under State v. Wettrich, the Oklahoma conviction did not have identical or narrower elements to any Kansas person offense, and it specifically looked at the Kansas battery of a correctional officer statute. In addition, the Court of Appeals looked to at that time, Court of Appeals decision in State v. Smith, which held that Wettrich was not a change in the law and therefore subject to correction as under a motion to correct an illegal sentence. What is important is the state did not petition for review from that decision. And on May 28th of 2019, the mandate issued. The mandate specifically ordered, as did the opinion, that Mr. Clark's sentence was vacated and the case was remanded with instructions. On remand, the original sentencing was scheduled for July 19th of 2019. That day, the state attempted to relitigate Wettrich, and whether it was applicable via the motion to correct a legal sentence. The district court asked for briefing, but on August 16, 2019, it held that it was bound by the law of the case, or the mandate rule, and it therefore had to follow the Court of Appeals' order. It resentenced Mr. Clark, treating his Oklahoma conviction as a non-person felony, and imposed a presumptive 216-month prison term. The state appealed from that sentencing. The first issue I'd like to talk about today is whether or not and there is any jurisdiction to even hear this appeal. And to resolve this, we kind of need to figure out exactly what the state is appealing. If the state is appealing the resentencing order in and of itself, as we pointed out in the petition for review, the failure to petition in the prior appeal rendered that decision final. So what was the result of that? Well, the result was the sentence was vacated under the plain language of both the order and the mandate. So the net result at the resentencing hearing on August 16th, Mr. Clark had no sentence. There was no motion to correct the legal sentence pending before the court. And we know under Murdoch 2, that the district court was bound to apply the law in effect at that time. What was the law in effect at that time? Wettrich was the law in effect at that time. As a result, there is no, so when the district court imposed a now presumptive sentence based upon the criminal history score under Wettrich and the appropriate severity level. We have a presumptive sentence, and as we know, this court lacks jurisdiction to review a presumptive sentence. Therefore, there's no jurisdiction. Now, I'm not really sure because the state's notice of appeal isn't clear, nor is their brief. But if somehow they're appealing some sort of new motion to correct a legal sentence, because we know the original one has been resolved and became final, the decision in that case, then the state's appellate rights are limited by statute. And somehow the state has to elect some kind of jurisdiction. The state's brief framed the issue as, did the district court judge impose an illegal sentence? It cited 223504, the illegal sentence statute. It also cited to 216820A, which appeals for the appeal of a departure. However, not mentioned in the state's brief is 223602F, which is the criminal procedure statute that allows the state to appeal from a departure. So 6820 allows an appeal from a departure, doesn't say who can do it, but 3602 specifically limits those rights, but does give permission to appeal a departure. Now, the problem with that, though, is this is a presumptive sentence. This isn't a departure. So there's no authority to appeal there. And then that brings us to our final point, which I suspect the court will have a full discussion on in the next case on the docket, State v. McCroy, which came from the same county as this appeal. And McCroy, the court looked at 223504 and found that it does not provide, it's not an appellate jurisdictional statute. What it is a source, a way to appeal something that was not raised below. Basically, you can raise an issue in an appellate court as long as you are properly in that appellate court, which is consistent with KSA 60-2101A and B. The statutes specifically say, in any case properly before it, the court may yada, yada, yada. With that in mind, we believe the state has no jurisdiction under KSA 223504 to appeal this. And as a result, there's just no jurisdiction for this appeal at all.
Mr. Dunn, what if we don't agree with your interpretation of the correct application of the law, and Wettrich doesn't apply and the sentence was erroneous? Does that create a path to jurisdiction for the state?
I'm not sure how the sentence could be erroneous when he was given a presumptive sentence, I guess.
Well, he's given a presumptive sentence, but if his criminal history score is incorrect, what path, if any, is available to the state? Is it just merely through or arguably through the illegal sentence statute?
Well, actually, if the criminal history was incorrect, if we look to 6820, one of the jurisdiction is granted to appeal the incorrect classification of a prior crime. And therefore, it would seem that under 3602F, in conjunction with 216820 sub B, I think it's E, but don't hold me to that. It's in 6820. Then there would be jurisdiction there. However, this was a presumptive sentence. There was no motion to correct before the court. And to date, there hasn't been one filed by the state. If somehow the state's brief could be treated as one, the problem is there was no avenue for them to get that brief into the Court of Appeals to begin with, much less an avenue for them to get them into this court.
Counsel, does it oversimplify your argument to just say it doesn't matter what the court's analytical process was, whether it was right or wrong, where it landed was a presumptive sentence, and so we're just done? Is that oversimplifying it, or would there be other things that might interfere with that simplification?
I think that's at this point, where we are in this case now, yes. This is a presumptive sentence. If you have the correct criminal history, which with the resolution of the motion to correct a legal sentence before that became final, that's what we're stuck with, right or wrong. And the reality is, and I frankly conceded in my brief, had the state filed a petition for review, we'd be in a very different position with at least these procedural arguments I'm making right now. Now, I have another argument I wanted to quickly get to.
Before you get to that, can I jump in and ask if we agree with you that basically the state is stuck and out of luck because there's no jurisdiction here? It just strikes me that may end up right back here if the state goes back to the district court and files a motion to correct an illegal sentence. Wouldn't that, I mean, I don't see what would prevent the state from doing that and raising these exact same arguments.
They can't.
Why not?
There's no illegal sentence anymore.
Well, but that's to be litigated. I mean, that's the question that's trying to be litigated, is whether or not it's an illegal sentence. And so procedurally, I mean, you and your client may still prevail, but procedurally speaking, there's no reason why the state could not, if you're correct that we are jumping the gun on the appeal, the state could go back to the district court and file an ordinary motion to correct an illegal sentence. Correct?
Yeah, they could. Okay. If we're talking procedurally, they could, but there's no way they should. There's no possible way to prevail.
I would argue that it would fail, but again, procedurally, the issue would be joined at that point.
Then it would be a motion to correct. No, I don't agree with that. I'm sorry, I need to back up. The state could. There's no question. Yes, if this court said no, there's no jurisdiction, we have to kick it back. The state could file it at that point, but then I'm assuming they lost, then they wouldn't be able to appeal.
Why not?
There's nothing they can appeal from.
I mean, you can appeal from a ruling on a motion to correct. What would prevent that? That's not an appeal of a sentence. It's an appeal of a ruling on a motion to correct.
No, my point is McCroy, and the rationale of McCroy is sound, I believe, says you can't if you're the state. The state does not have a motion to correct a legal sentence. Nowhere in there does it say that provides jurisdiction for appeal. It is simply a way to get around a lack of preservation, a lack of notice, a lack of something else.
Doesn't that upset a lot of our case law where we have, in fact, heard those exact kind of appeals from both sides? In fact, on numerous occasions, we have permitted parties to effectively file motions to correct as an appellate matter.
If it's already in the appellate court properly, then you can. But you have to have a way to get into the appellate court. And all this is laid out in the Court of Appeals' opinion in State v. McCroy.
So your view is that the state simply cannot get the merits of a motion to correct in front of an appellate court unless it's already there on some other issue.
Correct.
Okay.
That's what McCroy had. And as McCroy pointed out, if the state wants to go to the legislature, which I have no doubt, if McCroy goes the way I believe it should, the state will, then that's where it goes. This court should not be creating jurisdiction via judicial fiat, which is what the court would be doing if this court held otherwise. The rule is that all jurisdiction is statutory. We don't make an inherent jurisdiction. We don't allow for that for these sorts of things just because we want to. And the state doesn't have the right to appeal. The state can't appeal from a judgment of acquittal. There are just certain things the state cannot appeal from. And absent statutory jurisdiction, the state can't appeal. Statutory authority, can't appeal from a motion to correct legal sentence. I want to dip briefly into my rebuttal because I do want to touch on my last issue, because I have desperately wanted to get this issue before this court for the last 2 years. And that is, it doesn't matter about whether or not Wettrich was a change in the law, because the bottom line is Apprendi is the date this court needs to be counting from. Apprendi was said judicial fact finding is not permitted when it increases a penalty. That has to be done, found by a jury and beyond a reasonable doubt. We believe this is required under the doctrine of constitutional avoidance. Goes back to 1804 under the doctrine, and it's phrased other ways now, but under the doctrine, a court must take every reasonable construction to save a statute from unconstitutionality. If two possible statutory interpretations exist, one which raises constitutional problems, the court must utilize the interpretation avoiding constitutional problems. Now, part of the problem with this comparability analysis is people have framed it as a constitutional issue, but it's not. It only becomes a constitutional issue if the court interprets it under the old horseshoes and hand grenades test, as I've called it before, where close is good enough. If it is the identical or narrower test, then there's no constitutional problem. Therefore, under the doctrine of constitutional avoidance, it has to be treated as an identical or narrower test. When was that required? The root of all of this is Apprendi v. New Jersey, which was decided in 2000. That was 5 years before Mr. Clark was sentenced, and therefore the law at the time, regardless of whether it was recognized by this court, the law had to be, or else we had an unconstitutional statute, the law had to be comparability was determined by the identical or narrower test. It's simply, yes, there was another route to reaching that this court used in Wettrich, but that's not the only reason, and that reason was based long before that in Apprendi.
How does that apply here, though? You have an August 2019 sentencing proceeding. Why wasn't the law at that time the amendments that were passed by the legislature in 2019 that went into effect a few months before the August sentencing? Why are we not looking at the new statute rather than Wettrich?
Moving to a completely unbriefed issue, there's serious ex post facto problems with that. The punishment is what's in effect at the time of the offense, which was in 2005. And the punishment is determined by criminal history. So you can't change how you compute criminal history 15 years later.
The statute has a retroactivity provision.
It doesn't matter if it has a statutory retroactivity provision if that retroactivity provision violates the ex post facto clause.
But don't we have to think about that to get to where you want to be? I mean, don't we have to step through why that statute does or does not apply?
Well, that I think if the state wanted to then raise, I feel like we are now 5 steps beyond what's required in this brief. First of all,
well, I understand different than what you've briefed, but I just think it's something that can't be ignored before we jump to an Apprendi issue that may or may not, that may change. I mean, it may be a different issue, a different analysis than what you're suggesting.
If the court would want supplemental briefing on that and we can argue about it. Sorry, I'm caught a little blindsided there with no time left in my main part, but I think that there is an obvious ex post facto problem here. The legislature tries to do all kinds of things when the state goes over and says, oh, go stick a retroactive provision on it. But that doesn't make it so. You can't just say, I mean, you can't violate the Constitution via statute. The state could not go to the legislature and say, we want a statute that says police can search anyone at any time for any reason. That would be unconstitutional. So what if there's a statute that says that? It's not a valid statute. Likewise, you can't change a punishment and say this is retroactive after the fact when it clearly violates the way the punishment is calculated. There's notice problems with that. It clearly changes the punishment way after the fact. So, and that's all I can discuss, without, I don't have that statute even in front of me at the moment. I believe we have other arguments about that we made way back when it was before, but that's the most glaring problem with it I can see right now.
Any other questions? Thank you. Mr. Stanton?
Thank you, Your Honors. The problem with the defense argument in this case is that the defendant wants to apply only the law, only Wettrick to this analysis. You also have to apply Tower and Dawson to this analysis. Those cases were both decided the morning that this case was originally set for resentencing. So you have a court of appeals who issues a mandate based on Wettrick. Before the defendant is resentenced, you issue Tower and Dawson that day. And in doing so, you set aside the Wettrick decision. So the question becomes whether or not the district court was bound by that mandate or should apply the law as you determined it before this sentencing. Those cases made it very clear that Wettrick was not retroactive. And that is consistent with Apprendi.
Counsel, real quick, if I understand your argument to me that the Court of Appeals decision was wrong on the day it was issued because of cases that this court issued on the same day, why not petition for review at that point? If you knew the Court of Appeals decision was wrong the day it was issued.
We didn't know it was wrong the day it was issued. It was issued earlier. What was issued the day of sentencing were your new rulings that changed Wettrick and changed the whole dynamic.
Okay, so you're correcting me, I take it, that those decisions from this court were issued at the time of resentencing. I had it in my mind that they were issued on the same day as the Court of Appeals opinion.
No, my understanding is that the reason the court asked for briefing on the issue was because those cases came down the day he was scheduled for resentencing. Those cases came down July 12th of 2019. And that was also the date that Mr. Clark was originally scheduled to be resentenced under the mandate. And so the court ignored your rulings and followed the mandate instead. And so at the time he sentenced Mr. Clark the second time, he was ignoring your law, your rulings. And so my understanding has always been that a Court of Appeals ruling cannot supersede a ruling of the Supreme Court, even if it's a mandate. If it's wrong and you have changed the law as the Supreme Court, then Judge Chambers should have found criminal history category B rather than C and sentenced him to his original sentence.
Counsel, let's go back to the defendant's argument that I've tried to oversimplify, which is it doesn't matter if where the court landed that day was a presumptive sentence.
Well,
why doesn't that just stop this appeal dead in its tracks?
Well, because it may have been a presumptive sentence, but it was an illegal sentence. If the judge sentences a defendant using an improper criminal history, that is a departure from the sentencing guidelines. There was no notice of departure, and the court made no findings of substantial and compelling reasons to depart.
Oh, let me just ask about that. I can understand your claim that sentencing with an incorrect legal history makes the sentence illegal. I don't understand the claim that it's a departure.
Well, if the sentence is supposed to be within the box for a criminal history category B, and the court decides to sentence outside that box, he's departing from the guidelines. It may not be characterized at the time as a departure, but he is departing from the guidelines. And that's why the state has a right to appeal, because it was a departure from what the guideline sentence should have been.
Counsel, did you argue at the district court that this was an illegal sentence?
Now Judge Schroeder had this case. I was the deputy at the time. And I believe if you look in the record, he did in fact argue that the criminal history category should be B, not C, because of the cases that came down on July 12th. The sentencing was continued over to August 16th. And so those cases had been decided a full month before the court actually made the decision to resentence under criminal history category C.
Do you recall if that argument was framed as an illegal sentence argument?
I cannot say for sure. I suppose that if the prosecutor was arguing that it was an incorrect criminal history and the court should sentence under criminal history category B, then that would be, even if you didn't use the context, this is an illegal sentence, that would be the argument that was being made at the time of the resentencing.
And then your statutory basis for appeal, are you relying on 3504, 223504, and the general authority of the court to correct an illegal sentence at any time that the defendant is serving such sentence?
I think we're relying on both statutes. I think we're relying on the authority to appeal from a departure sentence and the authority to appeal from an illegal sentence, because this is the situation. That statute indicates that an illegal sentence can be modified at any time. Let's say the state files a motion to correct an illegal sentence, and a district court judge says, no, it's not illegal. And they ignore the law, or they find contrary to the law. The state then has if this court finds that there's no right for the state to appeal an illegal sentence, then there's no remedy for this court to even to hear this. So there is, under that theory, not separate from the first argument that I made. So what you'd be saying is that there's no way for a prosecutor to ensure that a defendant had a legal sentence rather than an illegal sentence. And it goes both ways. It's not just if a court were to find that a sentence for a defendant was proper and the state was thinking it should be longer. What happens when the state believes it should be shorter? And the court rules, no, Mr. Stanton, you're wrong. The defendant was properly sentenced, and I know, based on your case law and what I know about the case, and I believe that to be an illegal sentence. I have no way of taking that then before the appellate court to ensure that defendant's constitutional rights to a legal sentence are upheld. So I believe, you're looking at it, I think it's inherent in that statute that especially when you combine that with Section B of 602101, that says the Supreme Court shall have jurisdiction to correct, modify, vacate, or reverse any act, order, or judgment of the district court or court of appeals in order to assure that any such act, order, or judgment is just, legal, and free of abuse. You have jurisdiction, whether it goes through the court of appeals or not. You have jurisdiction to ensure that any order of a district court is proper. Otherwise, that statute means nothing.
But if you look at those two statutes you cited, they discuss the authority of the court, presuming an appeal is properly before it, at least arguably. If I understand, that's what your opposing counsel is arguing, and that the legislature knows how to draft a statute that grants the state or a defendant a right to appeal, as you've illustrated with the departure statute under 6820. And we don't see that language here. Is that correct? How do you respond to that construction or that statutory interpretation?
This court has always found, as long as I've been practicing, that the right to appeal is statutory, and I agree with that. So if the court requires explicit authority, then it would require explicit authority. But we have that under the departure statute. So we're before this court properly under any circumstances. The court could find that that you have jurisdiction under that statute because this is an illegal departure, and then go on and deal with whether a mandate from a court of appeals overrides your rulings that would change that law, and then the Apprendi issue, which the defense has brought up. So I think the question is, are we properly before this court? And my argument is we are clearly properly before this court.
And as I understand, at least from the docketing statement or notice of appeal, are you also suggesting that we have jurisdiction under 223602B? I can't remember the subsection now, 3, I believe, on questions reserved. Are you suggesting that you've raised an issue or a question that has been reserved for our review?
I am not suggesting that, because my understanding on a question reserved is that this court could rule on other cases, but it would not apply to this case. And if that's so, I am not asking this court to find that we have jurisdiction under a question reserved, because otherwise, if the court were to find that, it would not apply to Mr. Clark's case. So I'm asking the court to find we have jurisdiction. Quickly on the Apprendi issue, this court and courts across this country have found that Apprendi is not retroactive. What the argument being made by defense counsel here is that you should decide that the cases cited in his brief regarding the ability of a court to make a fact-finding determination should be applied retroactively. Not even Apprendi was applied retroactively. It was only applied to those cases that were pending at the time Apprendi was decided. And so now what's being asked of you is that you go back and you change that whole line of rulings that have been consistent over the years, that a change in the law does not apply retroactively. These are all changes in the law that the defense wants to have apply retroactively, clear back to Apprendi, and relate them to Apprendi. And that's not what you have done in the past. And so all of your jurisprudence regarding Apprendi and all of the cases where you have found it would apply also to Tower and Dawson in Mr. Dunn's estimation, because we would always have to go back, and every time there was a change in the law, we'd have to go back and say, well, we should have known this then. And since we should have known it then, now we have to change the sentence. And this court has rejected that theory over and over again.
Are there any questions?
If this court agrees with your opposing counsel and decides to rule that there is no appellate right for the state from a motion to correct an illegal sentence filed in the district court, would that mean that there's also no right of appeal for a defendant from the same motion?
I believe that is correct.
Any other questions?
Just briefly, what law applies once we get to the merits? Was the sentence vacated, and what effect does that have? Which law should be applied to the sentence?
Well, the sentence was vacated, but your subsequent rulings in Tower and Dawson would require that the original sentence be reimposed. And of course, the state would have a right to file a motion to correct an illegal sentence, citing your rulings in those cases, and we would be right back where we started as far as the sentence, and I suppose relitigating this issue again.
Anything else, Mr. Stanton?
No, Your Honor. Thank you very much.
Okay. Mr. Dunn, you're reserved 3 minutes. You are muted, sir.
Thank you, Chief.
Mhm.
That's going to happen, I'm sure.
Yes.
I think the first thing, Justice Stiegel, your last question to Mr. Stanton was, can the state appeal a motion to correct a legal sentence? And the answer is yes. And why can't the state if the defense can? That is because 223602B says, appeals to the Court of Appeals may be taken from the prosecution for cases before a district judge or a district magistrate judge who is regularly admitted to practice law in Kansas as a matter of right in the following cases. And here's the important part, and no others. There is no language like that for the defense. So the state is cut off. It is limited by that language. There is no such limiting language. That's why the defense can do it, but the state can't.
What statute does a defendant rely on to appeal in a guideline sentence? So it's a presumptive sentence. How does the defendant in a hypothetical case that doesn't have all these complications that we're dealing with, it's just a straight up motion to correct an illegal sentence was filed by the defendant in the district court. The defendant loses, but the defendant is convinced that the district court got it wrong. How does that defendant trigger appellate jurisdiction?
One of the ways is via 60-1507.
Well, that's not appellate jurisdiction.
Well, it can treat it as a 60-1507, correcting you have to have a procedural vehicle. And McCrory points out that subject matter jurisdiction, same way. We can bring subject matter jurisdiction at any time, but you still have to get into the proper court to be able to do it. So if you file a motion to correct a legal sentence via a 60-1507, then you have statutory authority as a matter of right to appeal that adverse judgment. That's one of the possible ways of doing it. The first one that comes off the top of my head. One of the things I think the state is really the flaw in this, and I don't want the court to get caught up in this, is that at the time, when, as the court pointed out, after the mandate was issued, Mr. Clark had no sentence. He had to be sentenced. There was no pending motion to correct a legal sentence. There's no way to relitigate that now. That's been litigated. And the fact of the matter is, the state didn't file a petition for review. There are consequences for that. Petitions for review mean something. Had the state filed that, we would be in a totally different circumstance. But the bottom line is they didn't. There was no pending motion to correct a legal sentence. So there was no way. You don't get to go back and say, oh, too bad, the law changed. The state's asking for retroactive application of Tower and Dawson. The reality is, and I'd also point out, the state's relying on Tower and Dawson. Weber came down June 14th before the resentencing in this, but Murdoch 2 came down the exact same day that the Court of Appeals issued its unpublished decision. Murdoch 2 came down that same day. This wasn't something new. The state should have looked at Murdoch 2 and said, if it wanted to pursue this, we're going to file a petition for review. They didn't. So the effect was, when the Court of Appeals vacated his sentence, and when that case was remanded, we don't get to go back in time. We don't get back to go back in time prior to Wettrich, back to when it would have been something that would have been necessary via a motion to correct a legal sentence. There was no motion to correct a legal sentence at the resentencing. We just have a simple sentencing. And at a sentencing, we know from Murdoch 2, you apply the law in effect at the time. And at the time, the law was Wettrich, identical or narrower. There is no question about relitigating this prior appeal. Whether it was wrong or not, it's too late. It doesn't matter. There is no motion to correct a legal sentence to change the decision in. The only thing is, did the district court follow that sentencing? If we look to the definitions in 216803, a presumptive sentence is a sentence imposed with the intersection of criminal history and severity level of the crime. That's what we had here. A departure departs from that presumptive sentence. It didn't depart from that presumptive sentence. The state is wanting to quibble about what the appropriate criminal history would be. That's a different argument than this being a departure. And that's recognized with the authority in 6820 to appeal the classification of the severity level of a crime or the prior criminal history, the classification of a prior crime. That's not a departure, what the state's talking about. That's a different kind of appeal. Just because it didn't hit the presumptive box they wanted doesn't make it a departure. So for all of these reasons, first, we claim there's no jurisdiction. Second, we claim that, and one final touch, Apprendi, we're not asking for retroactive application of Apprendi. We're asking for application of Apprendi. This is nothing retroactive. The law is what it is as of 2000 when Apprendi came down. We're not trying to upend any retroactivity things. We're just saying that's what the law is. That's how it has to be sentenced. So for all of those reasons, the district court was correct and has to be affirmed. Thank you.
Any questions? Thank you to both counsel for your arguments. We will take this appeal under advisement. The court is now in recess until 11 a.m.